Thanks for the invitation to participate in this interview. I am Secretary General of the International Institute for the Unification of Private Law, UNIDROIT, which is not an institute, it's an intergovernmental organization with 65 member states, but which account for 74% of the world population and more than 90% of the world GDP. So basically the world's market is represented by our constituency. And we are 100 years old. So we've been around for a bit, and what we do is we draft treaties and create standards, model laws through a public, inclusive process. And I'm the Secretary General, therefore I'm leading the secretariat of the organization. Our mandate is to do work on private law harmonization, and a very good chunk of what we do concerns access to credit. In the area of access to credit, especially for small and medium enterprises, there is a struggle pretty much everywhere, which is banks will require from you movable assets as collateral or immovable assets as collateral, and most people, startups, small entrepreneurs, don't have anything to give, therefore have no access to credit. That credit gap is usually covered in developing countries, but not only, by providing the one type of collateral that is directly linked with the business case. So if I have a good business, what asset do I have? My asset will be my ability to generate claims against third parties, my ability to generate receivables. And what the model law factoring does is provide a very modern, efficient system for a country to facilitate access to credit by providing receivables as the collateral. So it's receivables financing. It is a quite fragmented, complicated area, because this is one of those areas of the legal landscape where civil law jurisdictions and common law jurisdictions differ substantially, and also even within civil law jurisdictions there are very many differences. So we faced a landscape with countries with no regulations, countries with old regulation, countries with regulation which is relatively modern but incompatible with other countries that were creating norms that were state of the art. So it was much necessary to come to some sort of harmonization. That's why the World Bank, that is a development organization that works around the world and identifies the shortcomings of the legal frameworks, knocked on our door and said, you need to provide some standard on factoring. We worked with the FCI, we work with the World Bank, with the ADB, with the industry, but also the private and public sector organizations that are relevant in the field. And we came up with this model law, which is actually already being very much used in many countries. The benefits are plenty. It's not just about having harmonized one, it's having harmonized one at the top level. So first of all comes the modernization of the system. Our model law offers a very slim, effective, no fat in it, clear-cut set of rules with a registry which everyone can access for free. So no need for notifications, all these things that slow down the assignment of claims. It's a system that is very efficient also in enforcement and collection of the debts, and therefore in this entire structure of the operation of assignment of claims. That by itself implies substantive transaction cost reductions. If you reduce the cost of trading and increase the ability of small entrepreneurs especially to access credit, you're rendering an amazing service to the legal community, I think. Well, the model law itself is a soft law instrument in the sense that it's a model law you take it and it's designed to be incorporated directly as it is. But of course, in light of the specific requirements and nuances of the country, you might need to tweak it here and there. So it provides flexibility, and that way it adapts to local systems. I should also say, though, that the whole process of drafting the model law, we have in the room representatives of fully developed economies, of developing economies, of middle-income economies. We had representatives of financiers, of debtors, of international organizations. Having everyone in the room discussing that gave us a result, a balanced type of system which anyone can apply. Fully developed jurisdiction and a less developed jurisdiction, they both can use the system without any frictions. It's designed to work everywhere. Right. Well, absolutely. That was taken into consideration as well when we drafted the model law. It doesn't have a specific section on Sharia law, but the way that is designed allows for full application in a Sharia law system. And to give you just a couple of examples, the prohibition of interest, I think it's called the riba, is something which is completely outside the scope of the principles. There's no rule in the model law that requires interest to be charged in the transaction. So it's completely agnostic in that sense, and it's perfectly Sharia compliant. Another one is our description of the type of receivables that you can assign through our model law, and it provides for a general description. So it says receivables originated in the context of the sale of goods and services. So it doesn't go beyond that. So in order to avoid, for example, transactions which would be outside the halal, the permissible trade, it would be up to the country to simply state which of those transactions would fall outside. So using our model law, carving out those that in accordance with their religious values shouldn't be covered, that's enough. And to give you an example as to why our model law works very well in Sharia law countries, the first country to incorporate a model law was the United Arab Emirates, for which a place where obviously Sharia law is taken very seriously.